Welcome back and thank you for staying with us. Now, following our phone-in segment on presidential powers over governors, we now turn to the Supreme Court's recent ruling on emergency rule and its political and constitutional implications. Now, on Monday, the Apex Court, in a 6-1 decision, affirmed that the president has the constitutional authority to declare a state of emergency in any state and may suspend elected officials, but only for a limited duration. Now, Justice Muhammad Idris, delivering the lead judgment, emphasized that Section 305 of the 1999 Constitution allows the president to take extraordinary measures to restore normalcy, granting discretion on how to act in such circumstances. Now, the ruling arose from a suit by attorneys general of several PDP-controlled states challenging President Bola Tinubu's emergency declaration in Rivers State, which saw elected officials suspended for 6 months. Now, the Supreme Court dismissed the suit for lack of jurisdiction and ruled on the merits in favor of the federal government. Justice Obande Ogunya dissented, agreeing the president can declare an emergency, but arguing it should not extend to suspending elected officials. Now, joining us to unpack what this means for federalism, governance, and the future use of emergency powers is Mr. Mutiu Akinsanya, a legal practitioner and a public affairs analyst. Thank you for joining us this morning.
Thank you for coming.
Thank you for having me.
Good
Absolutely.
morning.
I was butchering names. I hope I didn't butcher yours. All right. Now, looking at this Supreme Court judgment, can you briefly summarize the court judgment on the emergency rule in Rivers State, and what was the legal basis for the judgment at this point, and what exactly did the court decide, so that we can understand in somewhat of a layman's term?
Okay, thank you very much. So I think the judgment is very simple. Those who went to court were PDP governed states across the country to challenge the powers of the president under Section 305 of the Constitution, to ask the court to interpret whether the president has those powers as contained in those provisions, and putting it in context of what happened in Rivers State. So the court held that those states that were before it had no cause of action, because this particular situation did not occur in those states. Rivers State, where the president declared a state of emergency, was not before the court. And so they had no cause of action. They had no reason to be before the court. If anybody will come to complain about what happened in Rivers State, it should be Rivers State itself. So you cannot shave somebody's head behind him. So the court simply held that it was not their business. They were just busybodies. And so the court said they had no cause of action. They had nothing to complain about. They had no grounds before the court. And the court simply said it lacked the jurisdiction to even listen to them because they had no complaint in the first place. But the court still then went ahead to say, okay, let's even look at Section 305 of the Constitution and ask the question on whether or not the president has the powers to declare a state of emergency. And then they say, yes, those provisions in Section 305 are very clear, that yes, the president has the powers to declare a state of emergency in any state across the country. But there is still a big problem. And I'm sure, I've not read the whole judgment, but from the Supreme Court saying it has no jurisdiction, that will not give the Supreme Court the opportunity to deal with Section 305 side by side the facts that occurred in Rivers State. And so what that means is that in the future, we may see the Supreme Court even deviating from what it held yesterday. So the circumstance in future, or the facts in future, will have to determine whether the president has acted within the provisions of Section 305 or whether he has acted beyond those provisions.
Now, looking at this particular state of emergency that was declared in Rivers State, a lot might say that there's a glaring difference between past declarations of state of emergency. Now, in this particular situation, was the declaration of emergency rule in Rivers State constitutionally justified when it comes to the stipulations of, declaring that state of emergency?
So if you ask me personally, I will say the president has not done anything wrong. I'm not referring to the judgment of yesterday, looking clearly even at the provisions of Section 305, because you see the way Section 305 is couched, it gives the president the discretion to come up with the details of the state of emergency. And looking at the entire provisions of Section 305, there is nowhere where the details is contained in that section. So who comes up with those details and transmits it to the National Assembly? It is the president. So the president can decide to include whatever he thinks should be those details and then transmit it to the National Assembly. But we must understand that we run a system of separation of powers, a system of checks and balances. So the president does not have an absolute power when it comes to declaring state of emergency. That power can be checked by the National Assembly. And the National Assembly is filled with men and women over 500 or thereabouts. Yes, who one will expect should be men and women of wisdom, who can spot wherever the president has exceeded those powers or where he has not.
Now, to clarify what you're trying to say, you said the president is the one to give those stipulations when it comes to, or what is going on when it comes to declaring that emergency rule or state of emergency in a state. But at this point, do you think that now, according to the Constitution, even though you said there are restrictions to it, did the criterias were the criteria met when it comes to declaring a state of emergency? Now, one of the criteria are the National Assembly have to approve this state of emergency.
Yes, so in the case of Rivers State, for instance, the National Assembly approved it. But you see, the problem I had with the National Assembly approving that state of emergency was that the National Assembly did not debate. If you watch the debate, it was not a thorough debate. It was not a debate where you see people really debating, talking about this thing, arguing, and then coming to a conclusion. The National Assembly in this case was just like a rubber stamp because there was no robust debate on the issue. But if you ask me, looking at the facts as at that time, whether or not the president was right or wrong, what was clear at that time, and I think it was reported across our mainstream media and even social media, that there were threats to bomb the oil pipelines, and that there were some bombings of oil pipelines, about 2 or so. And that's a threat to national survival because the mainstay of Nigeria's economy is crude, even though now Nigeria is trying to diversify. So if anybody bombs that crude, it is like attacking the artery of a human being. It is like wanting to attack the economy and the security architecture of Nigeria. And unfortunately, throughout that entire situation, the governor of the state never reacted. What the governor would have done at that time was to take some measures, right? And if need be, rush to Abuja and report the situation to the president, because the president is the commander-in-chief of the armed forces. Situations like that may even require the president to even send the armed forces to go and ensure that the economy is not under threat. But the governor never did all of these things. He was so relaxed, and from his body language, it seems the governor was contented with that situation, because those who were making those threats also posed themselves as supporters of the governor. And so that also puts the governor in the eye of the storm. the governor was also seen allegedly to be complicit, and he never redeemed himself. If you look at Section 305, Section 305 also gives the governor the opportunity to make presentations to the president. So the president can also decide whether a state of emergency should be declared or not. But the governor of Rivers State never did all of those things, right? If he had done those things, he would have redeemed himself from being suspended, my opinion. So I think what the president did was right. I think the governor himself was somehow complicit, and he couldn't have been left in that situation of state of emergency.
All right, looking at the River State saga that happened, people would say, the governor was a bit overwhelmed because, the issue had to do with the issues he had with his political godfather and whatnot. But since we're talking about how much power the president has in declaring a state of emergency in the state, I want us to look at the suspension of elected officials. Now, one of the most controversial aspects of this ruling is the court's position that elected state officials may be suspended during an emergency, provided the suspension is time-bound. Now, considering that the Constitution does not expressly mention suspending governors, how did the court legally justify this position?
So if you look at the word there, that they may be suspended, and that's why I say every situation will decide what the president will do. The Constitution gives the president that power, that discretion to be able to decide what should be the details of a state of emergency. So if the president sits in his room and he feels that an elected official should be suspended, so be it. But like I said, it is not absolute, right? It still goes to the next stage, that is the National Assembly. So if the president says, elected officials in so-so state where I've declared a state of emergency should be suspended. If it gets to the National Assembly can decide to review or to modify it, as the case may be. But you see, where the president says they stand suspended, and it gets to the National Assembly where you have not one, not two, not three persons, so many wise men, more than 3 wise men, and they also look at it and say, so be it. I honestly do not think that if the president is wrong, that those numbers of individuals at the National Assembly should be wrong. And in this case, right, even though Rivers State was not before the court to say its own side of the story, but we've seen now a concurrence, right, whether rightly or wrongly, of the president, of the National Assembly, and of the Supreme Court to say suspension of democratically elected officials can or may be done even in declaration of a state of emergency. So what it means is that what the president did, either directly or indirectly, was right, because we have seen the concurrence of the 3 arms of government.
All right. Now, looking at it with what my colleague just said about the suspension, the powers of the president to be able to suspend governors. Now, at this point, to what extent does this judgment strengthen or weaken the separation of powers in Nigerian federalism? Is there an implicit rebalancing of powers between the federal and the state governments as of now?
So the way our constitution is, right, you have devolution of powers from the federal to the state to the local government. And then you have separation of powers across the arms of government. So powers come from the center and then down to the states and then down to the local government. And if you look at the Constitution, you also see that the Constitution has specified what the federal government can do or what they cannot do, or what is exclusive to them. It has also specified what the states can do and what they cannot do, right? It also explains what the federal can do and what the state can do. So the state is still very autonomous. There are certain things that the president cannot do, even when it comes to states. For instance, the governors continue to remain the security officers of their states. If the president says, oh, he's coming to Plateau State, for instance, and the governor say, oh, as a security officer of this state, President, I don't think you can come. So be it, right? So there are areas that the governors are very powerful, and there are areas that the president is very powerful. But if you look at the state of emergency as provided under the Constitution, it gives that power to the president. Because even the state governor cannot declare a state of emergency in his own state. He can only make presentations to the president to decide whether a state of emergency can be declared in his own state. But for me, again, there are several implications to this Supreme Court's judgment. Because the situation in Rivers State was very dicey. Rivers State was a state under the People's Democratic Party. And a lot of commentators out there felt that why the president did that was to score a political point. And today, we have seen even the governor of Rivers State, who never challenged what the president did in court, now defecting to the All Progressive Congress. And so, what it looks like that state of emergency was used to score a political point. But because Rivers State was not before the court, it then becomes very difficult to really say what was the position of the state.
Now, at this point, as you made mention, with allegations of political motivations when it comes to a River State, how do you think the momentum will be in the state with, as you just mentioned, the governor defecting to the APC? We have to look at these variables, because at the end of the day, as you made mention, it was a PDP state and now a defection to the APC, and there were lots of chatter when it came to this state of emergency in River State. A lot were saying it was politically motivated. But what are your thoughts on it, and how do you think this judgment will evolve the political seas, and what kind of implications do you think it will bring to River State?
Yes, honestly, what I think I would have expected the Supreme Court to go a bit further in its judgment, not just to say that the president has the unfettered powers to declare a state of emergency. Because you see, whatever is not clear, if you do not give boundaries to anything, there is a possibility that it can be abused, right? So, it is not about who is sitting as a president today. You will still have so many presidents coming and wielding that power. But it's very important that the Constitution is also able to also come up with some limits, right? Or to come up with a framework that will always guide the president when it comes to declaring states of emergency. That framework is not contained in the Constitution, like I said. But you can still have another framework, maybe another legislation that can be made further to what you have in the Constitution, that gives an elaborate framework on what should be the considerations that the president will have to look at in deciding whether democratically elected government officials can be suspended, in deciding what should be the details of a state of emergency. Because as it is now, the president can even say, oh, I've declared a state of emergency, go and bring your father's head. That is what it looks like now. But if the Supreme Court had, even though it's not before them, as a matter of policy, if they had spoken about it to say, oh, we also think as an obiter that this can be done, it gives room for clarity. And it also limits the opportunity to abuse that power in future. You see, the problem with Nigeria presently is that we seem to be running a one-party show, right? And that's why, because the president, the members of the National Assembly are on the same page when it comes to party, majority, anything the president push at the National Assembly will not be subjected to that rigorous debate. If you have maybe a 60-40 or 45-55 ruling party and opposition in the National Assembly, I can tell you that if that kind of gazette or proclamation is sent to the National Assembly, you will have seen a robust debate. But it was a good ride for the president because majority were members of the All Progressives Congress, or majority already had their minds in that party.
It is interesting that we're looking and discussing about this topic, and if you look at it, Nigeria as a country claimed to operate a federal system, you know, where governors derive their mandate directly from the people. Now, with this ruling, are we seeing a shift towards a more centralized system, at least during emergencies?
Yes, so if you understand what emergencies are, or what a state of emergency is, a state of emergency is a desperate situation that calls for a desperate intervention. So it is not a normal state of things. And you see, it is not only Nigerian constitution that has provisions on state of emergencies. Almost all constitutions across the world have provisions when it comes to the state of emergency. And the discretion or the power to declare that state of emergency usually sits with the head of state or the president. In some countries, maybe like the United Kingdom, maybe the king, who is also like the president and all of that. But you have this all in every constitution in the world, even in the #1 democracies, in the United States and all of that. And why do you have this provision? You see, if you look at the situations where these provisions can be invoked as contained in Section 305 of the Constitution, you will find that it is because it is an emergency. If an immediate decision is not taken, right, it may lead to loss of life, it may lead to chaos that may not be controlled. So it does not allow for several people to come and then start deliberating, because the point of deliberation may even lead to worse situations. So you just need one person who can look at the situation, make a decision, and then push that decision for implementation. So I do not honestly think that it's a concentration of power in the hands of one person at the detriment of maybe the states or at the detriment of other people. It is only because it's a desperate situation that requires a desperate attention.
No. Okay. Now, looking at the reasons behind the state of emergency in Rivers State due to volatility when it comes to the oil pipes and all of that. Now, at this point, with this judgment, how do you think it will affect, you know, the relationship between the federal government and other oil-producing states? Could it, you know, create a precedent in similar disputes over internal security or governance issues?
Yes, so you see the kind of government that we operate. It's a government that is supposed to be symbiotic. Yes, the states are supposed to work with the federal government for the betterment of the people in the state and then for the betterment of people across the country. Oil pipelines are federal assets. They are not state assets. But they are assets that are sitting on state assets. The lands belongs to the states, but that oil pipeline and the content of the oil pipeline, the crude, is an asset of the federal government. So what you will have expected is to see a symbiotic relationship of collaboration between the federal government and within the state governments. So honestly, I do not think there's any problem. I only will advise that when these issues come up, you must see a cooperation between the states and the federal government, ensuring that the economy is not affected, ensuring that the states also do not also suffer any loss. Because by the fact that those assets, federal assets, are also situated in those states, it's also a great advantage for the people of those states and for that state particularly. But you see, in this Supreme Court ruling of yesterday, I think Rivers State denied Nigerians the opportunity to be able to deal with this issue once and for all, and to be able to get a proper guide on how these things can be done in future. Because one would have expected that Rivers State should go to court without fear or favor, without malice, to simply go and say, Supreme Court, please interpret this. So the governor should not have thought about his own political survival. He should have thought about really the country are making the country better. Because even if you take the federal government to court or you take the president to court, it is not because you have any malice against the president. It's not because you hate the president. It is simply because you want our democracy to be better and you want a pronouncement to be made. So politics apart, policies apart, and trying to make our country better should be everybody's priority.
So for that, do you think that the ruling set a precedent for future emergency declaration, or is it specific to just River State?
So I do not think it's specific to, I think it's just general. The Supreme Court just spoke generally on Section 305, that it gives the president the power to declare a state of emergency, including even suspension of democratically elected officials because of the way Section 305 is worded. Like I said earlier on, River State denied us the benefit of the Supreme Court situating the facts in River State within those provisions of Section 305, because River State was not before the court. And that is why the court said that those other states that were before it were simply busybodies. No state of emergency was declared in those states. So why were they before the Supreme Court? Why is it that the person who is affected is not before us? Or why is it that you didn't get the consent of that person before you come before us? Or why did you not drag that person to come before us? So that we can hear his own side of the story. Because you see the way our courts operate. Our courts do not operate based on what is on the social media or on the mainstream media. It is what is presented before the justices of the Supreme Court that they will use to write their judgment. So if no complaint from River State, it means River State is satisfied with it. So why are you worrying over the headache of another person? You know? So
well, speaking about worrying about the headache of another person, a lot of people, a lot of Nigerians would say that this judgment would raise concerns over judicial impartiality in handling this case. Exactly. So what are your thoughts on this?
No. So you see, in fact, the Supreme Court even was so magnanimous to even go into the merits, because they had no obligation to go even into the merit of the case, right? So they were being even magnanimous to say, okay, so that we're not accused of saying, oh, we use technicality to decline jurisdiction. Let's still go into Section 305, look at it and make a pronouncement on it. So the Supreme Court was being magnanimous. And because River State was not before it, I do not think there is anybody that will then accuse the Supreme Court of any injustice or of any partiality.
Now, with them being magnanimous, as you said, so does this judgment strengthen public confidence in the judiciary, or does it fuel skepticism? Because at the end of the day, we know how Nigeria is, and we know how much skepticism Nigerians have of the judicial system. So with this, does it give an example of cementing, how upstanding the judicial system is?
I think so. And I also think that Nigerians must also know that the judiciary does not activate itself, right? You can't sit back and complain when you are not before the courts, right? So our courts are not courts of sentiments. Our courts are not courts of public opinion. Our courts are institutions that deals with facts. And those facts must be presented before the courts. So you can't say because, oh, the Supreme Court justices are also Nigerians, that they watch TV every day and they read newspapers every day, they should know what is happening. Judges, the way judges are trained, they are trained to detach themselves from whatever they see or from whatever they hear outside. It is what is presented before them within that confine of the courtroom that they use to prepare their judgment and to deliver their judgments. So Nigerians must be confident to approach courts when they need to. And even when states also need to approach the courts, there should be no fear. There's nothing to worry about. That you have gone to court to seek for an interpretation of the law means you're doing more good to the system. But if you decide to say you won't go, and then you sit somewhere to complain, then you are being unjust to yourself, you are being unjust to your society, the community, the whole country, and then you're also not just to the system, to the institutions that we have. Because the best way we can strengthen our institutions, strengthen our laws, is by putting those laws to test before the judiciary.
So looking at the perception of Nigerians and also public accountability in a situation whereby, let's say, okay, for citizens who did not vote for the president but elected their governor, what does this judgment mean for their democratic rights during a state of emergency?
Absolutely nothing, because the citizens themselves, so I'll give an example. If not the attorneys general of these states that went to court, people in Rivers State, right, could have also gone to court.
Okay.
They couldn't have even waited for the government to go to court. People who feel that they are directly affected, people who felt that they went to the ballot, cast their vote for these elected officials, they could have also gone to court to say, Mr. President, you cannot override our ballots, right? But we didn't see any of them challenging this, right? Even the people of Rivers State themselves, we didn't see anybody going to court to challenge this. And that is why I say at times in Nigeria, we only sit back to complain. We do not avail ourselves of the opportunities we have with our courts, with the institution, to go to challenge some of these things. And if you don't challenge them, that is what the status quo will be. So if the people of Rivers State themselves had gone to challenge the state of emergency to say, oh, Mr. President, this you have done is overreaching, perhaps the court could have also looked at it differently. Okay. But the court has been denied the opportunity of looking at that side of their own story.
Now, looking at the future, what safeguards do you think should be put in place to prevent potential abuse of emergency powers, and are legislative reforms needed in making sure that everything is done according to book?
Yes. So I think policy experts, non-governmental organizations should begin to do publicity on the need to have a framework that would guide the president in issuing proclamations for state of emergency. And whatever framework that is come up with can also become a legislation that the National Assembly can adopt to pass.
Because it's quite scary when you said that the president can be able to stipulate what is going on and can be able to move forth with what he feels or deems fit to move on with.
Yes, because that is what Section 305 says. In fact, Section 305 says that the president would transmit the details of the proclamation of a state of emergency to the National Assembly. So what are those details? The president can sit in his office or in his room and can decide to write whatever he wants to write as those details. There is nothing to check him on whatever he wants to put down, except when he gets to the National Assembly, before the National Assembly can then decide to look at it and conduct a surgery on whatever the president has written. But I'm saying that even before the president puts certain things down, if we have a framework that also guides the president in putting whatever he wants to put down, or we have an addition into Section 305, an amendment to Section 305 that also provides some details that the president should include in that proclamation, it then puts the president, it limits the president on what he can do. But as it is now, that discretion and power that Section 305 gives to the president is unlimited, it is huge, and the president can decide to put anything therein. Like I said, he can even decide to say a governor or an elected official should bring his father's head. Just give, so it is unlimited,
All right, moving forward, how can the government ensure emergency powers are exercised responsibly without undermining elected state governments?
That is difficult, very difficult, because if the law allows for unlimited powers, right, then the person who is exercising those powers can decide to interfere with democratically elected positions. But you see, in the past, you see when it happened in Plateau, when it happened in Oyo and all of that, the presidents in the past, even when it happened in Borno State under President Goodluck Jonathan, elected officials were not suspended. The only time we have seen the suspension of elected officials is in the case of Rivers State. And I honestly think that in the case of Rivers State, both the members of the State House of Assembly and the governor, they were complicit. They were busy fighting when the state was on fire. You will have seen a situation where perhaps the State House of Assembly should have convened an emergency plenary session, right, to deal with the situation of bombing of oil pipelines, right? And a situation where even if the governor refuses to act, that they should have maybe passed a motion to ensure that the governor acted. But they were all busy with politics here and there, and while the state was about to be on fire.
No, the genesis of the problem in that state, started politically with the governor having issues with his political father. And, most Nigerians will say that. And that is why critics, still argue that the intervention of the president in declaring a state of emergency in that state is it's a bit of a dicey one.
Yes, that's true. But you see, there's a proverb in Yoruba that if you want to set fire on someone and the person uses palm oil to rub his body, he is also aiding that fire to engulf him or her. Yes. So when you know you are in a political situation and you know that the person on the other side may want to use your situation to put you in further trouble, then you need to be very, very careful. But what was important at that time was that there was a federal asset in the state that was now in danger. And the president can use that as an opportunity, even if he has a political motive. You have given him a reason to exercise that political motive. But I do not want to be sentimental to say, oh, it was political. What was clear was that there was a federal asset in that state that was endangered. And you cannot expect the president to sit back knowing that that is the heart of Nigerian economy, for him to sit back and say he would not take any measure.
All right.
Yeah.
Now, looking at this judgment, what do you think ordinary Nigerians should do, especially residents of Rivers State? What do you think they should understand about the practical effects of this judgment, especially in that state?
Nigerians everywhere should now begin to participate more in governance. There are certain aspects of our laws that perhaps we are aware of them, but over the years we have not activated them. Unfortunately, in Nigeria, we have so many elected officials who do not care about Nigerians, about people who have voted them into power. And they come back every 4 years to seek for re-election. For instance, the National Assembly, members of the National Assembly, they have, under the Constitution, situations where they can be recalled. We have seen how difficult that has been. Not because it is difficult, but because people are not really willing to be participatory in governance, to even recall certain members of the National Assembly. And that is why you keep seeing that the dividends of governance is not really getting to Nigerians. Even governors can be impeached, right? How many governors are being impeached? And how do citizens exercise the powers to ensure that governors that are not working for the masses are impeached? When you recall members of the State House of Assembly or of the National Assembly that are not doing their duties, or where, for instance, they are not checkmating the executive from ensuring that the dividends of democracy gets to the people, you can recall them. If they know that citizens can recall them, they will also ensure that they also checkmate the excesses of the executive. What am I saying? That Nigerians should be more conscious of our governance structure, and we should not just sit in our houses and complain. We should participate. We should write letters to our representatives. You can write letter to the president and drop it at the villa. Whatever you feel is wrong with Nigeria. But how many Nigerians write these letters? If the president does not respond, you can also institute actions against the president. How many people are bold enough to say, oh, I'm going to challenge what the president has done, and I want to take him to court? Because as a citizen, I'm not getting the dividends of democracy. If it is education that is substandard, all of that. You can go to court, you can challenge the president, you can write to the president, you can write to your governors, you can write to your representatives. So Nigerians were too docile, were not very participatory in government, and we only sit to complain that, oh, see what they're doing, when we do not want to participate. Participation is more than just going on election day to cast our ballots. After casting our ballots, because these people in government, they're human beings. And you see in sociology, they say every human being you see is a potential criminal.
All right.
So if you allow that criminality to come out and you don't check it, it becomes disastrous for everybody. It is not only these politicians you see. Even if it is me or these citizens that are there, will also behave like that if we're not being checked.
All right. Thank you very much, Mr. Mutiu Akinsanya, for your legal and public affairs expertise on this matter.
Thank you very much for having me.
Absolutely. You heard it here. Participate, not complain. We'll be going on a quick break. When we come back, we'll be looking at the front pages of our national dailies and see what made it there. We'll be right back.